to be removed from the Van Zandt County Jail on what I think is colloquially referred to as a white warrant. I know that phrase had been brought up in one of my discussions with either Mr. Woodwike or Ms. Heisel in reference to one of my clients here in Van Zandt County. I don't remember if it was Mr. Massey, but in any event, if it was my responsibility to get that motion filed, I did not fulfill that responsibility because here we are today. I will note that I actually filed an application for attorney's fees in this case the first week of September, which I will note has been paid. So if the court, if the judge, if you want to make that note on the court's jacket so I don't get paid twice on this, that might be a good idea. But either I need to get back to the office, Ricky Tick, and file that motion asking for a competency evaluation, or if there's another, if I'm right in the possibility that this was going to be dealt with a white warrant, I don't know. I'll note that Mr. Massey has been in custody now for over 160 days, and this is a Class B misdemeanor.
I don't have any knowledge of a white warrant state. Do you? Has anyone sought to have him placed in a state hospital? Has anyone sought that?
I am unaware of anyone seeking a mental hold on Mr. Massey. I was aware that there was some consideration for mental issues, but I was unaware that the sheriff's office was going to be seeking a white warrant or anything of that nature. I know we used to do that. I'm not sure what our the current sheriff's administration opinion on that. I think some of that the rules on that have changed in recent years, and I'm not 100% on whether they are equipped and ready to do that or not. I think Mr. Adam.
It may very well be the case that was not brought up in a discussion about Mr. Massey's case. My notes on this file are deficient in that regard. So in any event, I cannot, without committing legal malpractice, I cannot let Mr. Massey put his signature to any of the plea papers that I have. I cannot let him enter any kind of plea other than not guilty at this time. Well, there's one other one I could, but we don't have the wherewithal to do that today.
So what I'm going to need from you, Mr. Adams, is I'm going to need a motion suggesting incompetency supported by an affidavit. Otherwise, I don't have any other motion before me. I've got no communications from the jail regarding his mental health status, requesting. No one's filed an application seeking a mental health warrant.
I'll make sure it gets done today.
Okay, so I'll reset Mr. Massey then for an additional pretrial on January 25th. And if you'll follow the motion, then I'll review that without a hearing.
Yes, sir. I'll get it taken care of. Okay, Your Honor. That's all I have on the docket this afternoon. If the court will excuse me, then I'll race back to my office obeying the speed limit, of course, and file that.
Yes, sir. Thank you.
Mr. Stevens?
Okay, thank you. Thank you.
Okay, Mr. Schmidt? Your Honor, we have Mr. Schmidt and both of his clients in the room.
Mr. Schmidt, who are you ready on, sir?
Mr. Crutcher and then Mr. Powell.
CR 21-284, Christopher Crutcher. I show Mr. Crutcher set for pretrial.
That's correct, Judge. We don't have any contest at this point. That's the matter to be set for the after call.
And your next date is the 25th, right?
Of January? January, Judge?
Yes.
I will be here on that day. Yes.
I'm saying that's where we reset you because you had a vacation letter or something.
That's correct.
All right, so we'll set Mr. Crutcher then for a docket call on January 25th at 1:30. If he's in jail, 9 a.m. if he's on bail. Gerald Powell, CR 21235. Mr. Powell is set for docket call.
Judge, I noticed on your docket that he was set for docket call. It should be for a pretrial. We requested an additional pretrial last time we were here. In this particular case, Ms. Curry has indicated that she intends to have him independently evaluated by mental health professionals. I spoke with her today. She's in the process of getting those set up. And so at the end of our pretrial settings, eventually, we will have likely some contested pretrial motions, but we were trying to get the mental health evaluations tended to first. So it's my understanding from Ms. Curry that that's in the works from her side, and then we'll react to that once that's done. But it should be a pretrial, and we're asking that we get an additional pretrial on this issue as well.
Okay, court will reset Mr. Powell then for pretrial on January 25th. And we'll take up the state's evaluation of Mr. Powell at that time.
Thank you, Judge. Oh, I have to excuse.
Yes, thank you, Mr. Schmidt. And Deputy McLeish, I'll tell you that I do have Mr. Knoll available in the online waiting room. Also, Mr. Richard McConaughey. Let's see where perhaps he's put up here.
Who is his client, Your Honor? I don't see his name on my list.
We're thinking it may be Pedro Nino, maybe. Richard McConaughey, maybe, I'm not sure.
Okay, thank you, sir. We'll get those folks up here. And while we wait, we do have Mr. Stevens ready with his clients.
Excellent, okay. Dakota Dubose, CR 21212. All right, Mr. Dubose is set for pretrial, and we also have a writ seeking bail reduction. Let's take up the pretrial matter first. Do you have any issues with discovery, Mr. Stevens, or any contested pretrial motions?
No contested pretrial motions, Your Honor.
You feel like you have all the discovery in the case?
I believe I do, yes, sir.
Okay. All right, we will then set Mr. Dubose for a docket call setting. What did we set you for earlier this morning, Mr. Stevens, if anything?
It was January the 6th, Your Honor.
Okay, and that date's okay still?
Yes, sir.
All right, we'll set Mr. Dubose then for docket call on January 6th. And so now we'll take up your writ seeking a bail reduction. And it looks like Mr. Dubose is charged with sexual assault of a child, second-degree felony offense, and bail is set at $150,000. Is that right, Mr. Stevens?
Yes, that is correct, Your Honor.
Okay. Do you want to call your client to testify?
Yes, I will, Your Honor.
All right, Mr. Dubose, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. During your testimony, speak up loudly and clearly. It's going to be easy for Mr. Stevens to hear you because you're standing right next to him. He's asking you questions. You're not having a conversation with him, but you're answering his questions. So I've got a court reporter here with me, and it's important that both she and I hear what you have to say, okay?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
Dakota Lincoln Bose,
Dakota, how long you been in the jail now?
85 days.
Okay. And as the judge said, you're being held on a $150,000 bond, which obviously you haven't been able to post that, correct?
Yes, sir.
Do you have any cash to put towards that bond?
No, sir, not at the time.
Do you have any property that you could sell or mortgage in order to put towards a bond?
No, sir.
Okay. Yeah. If the judge were to reduce a bond, where would you live?
25,000.
No. Where would you live?
Oh, maybe in Texas.
Okay. And you would actually be living with your mom and your stepdad, correct?
Yes, sir.
Okay. And how about your work opportunity? Can you go to work if the judge reduces a bond?
Yes, sir.
Where would you go to work?
My stepdad, remodeling houses.
Okay. And do you have transportation to get to and from the courthouse or any other obligations the court may put on you?
Yes, sir.
Okay. And I think you've told me before, and I've visited with your family, and if the judge were to reduce a bond at $25,000, is that an amount that you believe your family would be able to post?
Yes, sir.
Okay. And if the judge does reduce it, can you promise this judge you'll make every court appearance or do any other thing that he's asking of you?
Yes, sir.
Okay. Pass the witness, Your Honor.
State.
Thank you, Your Honor. If I could find my unmute button. Mr. Dubose, do you understand that you have already been charged by indictment in this cause?
Yes, ma'am.
And do you know who the alleged victim in this cause is?
Yes, ma'am.
And do you know what her age was at the time of the alleged offense?
Your Honor, I'll object that question.
What's the objection?
Well, because we're sitting here trying to listen testimony from my client about a potential case that could go to trial. And him stating that he did or did not know her age could be very prejudicial to him, Your Honor.
I'll sustain the objection.
Your Honor, I have no further questions for Mr. Dubose.
All right. Do you have any other evidence, Mr. Stevens?
No, Your Honor, that's all I have.
State, do you have any evidence?
No evidence, Your Honor. We would just reserve for argument.
Go ahead, Mr. Stevens.
Judge, we're just asking to reduce the bond to $25,000. He does have a job. I visited with his family. He does have a place to go to live. He does have transportation to get back and forth to the courthouse. And it is a very serious charge. No one's making light of that. However, he's a very young man, Judge, and we're just asking to reduce the bond to $25,000.
Thank you, Mr. Stevens. Ms. Heisel.
Your Honor, the state is going to oppose any bond reduction on this cause. Mr. Dubose is already indicted. We are doing our very best to make sure that the judicial process is efficient for him. However, given the age of the victim, which is 13 years of age at the time of the offense, and the potential danger to the community, we're asking that his bond remain as is until the conclusion of his case.
Okay. All right, the court will make a ruling at the conclusion of the docket.
Mr. Howard.
Mr. Holloman, come on up, sir.
All right, this is cause number CR 21220, State versus Justin Lee Holloman. Set for pretrial.
Yes, Your Honor. We have no formal pretrial matters.
All right, there being no formal pretrial matters, the court will set this for docket call on January 6th.
Your Honor, if I may interrupt you, we do have a plea worked out. So if we could get it on the earliest docket, would be very, my client would be very appreciative.
Is that a plea for time or probation?
It's going to be basically reduction to a misdemeanor, Your Honor, and basically a time served plea. Yes, sir.
I could bring you back December 14th or December 16th. Those are the next two.
If we could do the 14th, Your Honor, because I'm in your court anyway on the 14th.
Okay, we'll set Mr. Holloman then for plea on December 14th at 1:30.
All right. Thank you, Your Honor. That's the only two I have. Might be excused, Judge.
Yes, thank you, Mr. Stevens.
Thank you, Judge.
Thank you, sir. Your Honor,
Yes, ma'am.
I do have the clients in the room for Mr. Knoll and Mr. McConaughey. Just let me know which one you want up here first, please.
Let's see which attorney picks up first. Let me ring them on the load here. Let me ring them on the telly. Mr. Knoll, can you see and hear me okay? I know this is new technology. Yeah, you go. You're that mute.
I think I'm working now. Am I working now?
You are working now.
Yay.
All right, let's see. Let me get your clients up here. All right, this is CR 21-225, State versus Michael Paul Marley.
Yes, Your Honor.
And Mr. Knoll, I believe that we're set for docket call today for a setting.
Judge, that I'm pretty sure that's correct. I received, I don't know if it was yesterday or the day before, but at any rate, about a 6-page, 5.5-page letter from Mr. Marley. The reason I mention that is because it contains some information I don't believe that I previously had regarding a medical procedure that he'd had just a day or two, if I'm reading this correctly, before the incident that causes him to be in your jail today. What I intend to do, because it's usually quicker and easier, I'll file a motion based on this information to obtain those records with the court to enter an order for them to send me those records, as opposed to a HIPAA request. HIPAA usually, one, takes longer, and two, they want you to pay for it. Usually if there's a court order, they will understand that it's needed for a case, especially where the defendant is indigent. And I would probably get that filed, as long as I don't get stuck in some other court, which I don't believe I will for the next couple of days anyway. Get that filed this week.
Any objection by the state? No.
Yeah.
No, the state has no objection. Ms. Heisel can't get her thing unmuted, but the state has no objection.
Okay.
New technology for Miss Heisel too, I guess. Yes.
They
Judge,
changed my setup, Judge, and I'm struggling.
okay.
I understand.
Judge, the only thing I'd request is, since it's the holiday time, which seems to slow everything else down also, instead of, I think I was reset to January 6th, if I could have a little bit longer, either towards the end of January or 1st of February, to make sure I have those records in hand. I don't want to waste another court setting if I don't have those records.
Late January would be the 25th. The next one after that would be February 8th.
Let's shoot for January 25th. Is that the 25th or 26th?
25th, Tuesday.
Okay.
All right, court will set Mr. Marley then for Tuesday, January 25th at 1:30.
Thank you, Judge.
You're welcome, sir.
Thank you, Mr. Knoll.
Yes, sir. Thank you. May I be excused, Your Honor?
Yes, you can. Thank you, Mr. Knoll. Good to see
Thank
you.
you.
Did you want me to bring Mr. McConaughey? Mr. McConaughey?
If he's ready, we're ready.
Let's see.
And if he's not ready, we do have Mr. Ashmore who's in the room and ready.
Mr. McConaughey, are you standing in for Mr. Bolton today?
Yes, I am, Your Honor. He is my law partner.
Okay, that's what I thought. Wanted to make sure, but didn't want to assume either. All right, Mr. Nino, if you can bring him up.
Yes, Your Honor.
All right, this is cause number CR 21-301, State versus Pedro Olivares Nino. We're set for a pretrial today, Mr. McConaughey.
Yes, Your Honor.
Do you have any contested pretrial motions, suppression, quash, anything of that nature? Any issues with discovery?
No issues with discovery, Your Honor. I would just ask the court if I could receive an additional pretrial. I'm still in the process of trying to connect with the state on receiving an offer on this matter.
Okay, what we'll do is I'll move you to the docket call setting, and that'll give you time to continue your negotiations with them. So if you have your calendar available, are you available either on January 6th or January 25th?
The 25th would work better, Your Honor, because we're in trial on the 6th.
All right. Court will set Mr. Nino then for docket call on January 25th at 1:30.
Thank you, Your Honor.
Thank you, sir. Appreciate you.
May I be excused?
Yes, sir.
I'm sorry, Your Honor, just verifying, you did say January 25th, correct?
Yes, ma'am. 2-5.
Thank you, sir. Yes, sir. Thank you.
Mr. Ashmore, do you have some clients ready?
Mr. Schroeder's here, Your Honor.
All right. This is cause numbers CR 2310, 37, 38, and 242, State versus Dillon, Andrew Schroeder. I have a mixture of docket calls with pleas. What are we doing today, Mr. Ashmore?
Judge, we are entering a plea on CR 21-00242. The terms of that plea agreement is, it's a plea of guilt to the bail jumping and failure to appear 3810F of the Texas Penal Code, third-degree felony, 10 years TDC, $2,500 fine, court costs, reimbursement fees, that's $290 and $70 respectively, 169 days credit for time served. And in exchange for that, the state is going to 1245 CR 20-00310, 2020-00514, CR 21-00037, CR 21-00038, and unindicted DA 2020-1074. Which should resolve all of Mr. Schroeder's matters in Van Zandt County, Texas.
Okay. Mr. Schroeder, sir, please raise your right hand. I'm going to place you under oath. Mr. Schroeder, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Make sure you speak up loudly and clearly so that I can hear you and my court reporter can take down everything that you say, okay?
Yes, sir.
All right, thank you. Your name is Dylan Andrew Schroeder, is that right?
Yes.
And Mr. Schroeder, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Very much, sir.
You feel like you had enough time to discuss your cases with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir, he explained everything that I needed to know.
And is that your true and correct signature that appears throughout the documents?
Yes, sir.
And Mr. Ashmore, do you believe Mr. Schroeder to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, Judge, we've had, I know I'm new-ish to his cases and cause numbers, but we've had some sufficient meetings to explain the benefits of the plea offer, the constitutional rights were given up in exchange for consideration of these other offenses and the resolution of all his business in Van Zandt County. So yes, Judge.
And you believe he understands the circumstances and the facts of the case and how the law applies to the facts?
Yes, Judge.
All right. Mr. Schroeder, you heard Mr. Ashmore read to me what the plea agreement is. Is that the plea agreement in your mind?
Yes, sir.
That's what you want the court to accept today?
Sir.
All right. So I'm required to tell you that the range of punishment for a third-degree felony offense of bail jumping or failure to appear on felony is, if convicted, is confinement of not less than 2 years or more than 10 years and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
And I would find here that based on what Mr. Ashmore has indicated, that you would be accepting a 10-year prison sentence, that would legally fall within the range of punishment. So understanding the range of punishment and you understanding the plea agreement, do you still wish to go forward?
Yes, sir.
All right. So Mr. Schroeder, let me ask you, how do you plead to bail jumping and failure to appear on a felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
The court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court does take judicial notice of Mr. Schroeder's judicial confession. Anything further from the state?
Yes, Your Honor. Even though they are being 1245, I still would like to give the court an update as to the victim on the 1245 causes. The victim did indicate to us that she wanted to come in and sign an affidavit of non-prosecution. I don't believe she ever actually made it to our office to complete that. However, it has been communicated to our office on more than one occasion that she does not wish to proceed with prosecution as to the aggravated assaults. So that is why we are primarily proceeding on the bond jumping case in this cause.
Thank you, Ms. Hodges. Anything further from the witness, Mr. Ashmore?
No, thank you, Your Honor.
Ms. Heisel, can you give me the facts to support the plea for the bail jumping?
I sure can, Judge. If I give me 1 second and I will get on here the actual date. Your Honor, Mr. Schroeder was set for, I believe it was pretrial on the aggravated assault charges in your court. He failed to appear on the, I believe it was the 13th of April. We actually have 2 different dates on the bailiff certificate, but I believe the date that he failed to appear was April the 13th of 2021. He was called, his case was called, his attorney attempted to reach out to him. And basically it was communicated to the court that he would not be appearing that day. Subsequently, the state filed this bail jumping charge.
Thank you, Ms. Heisel. Mr. Ashmore, any objection to that summary?
No, Judge, that's what we understand the facts to be.
All right, then based on the evidence presented to the court does find that there is sufficient evidence to convict Mr. Schroeder of bail jumping. Court will follow the plea agreement in this case. Court hereby convicts Dylan Andrew Schroeder of bail jumping and failure to appear. Third-degree felony. The court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $2,500 fine, $290 court cost, $70 reimbursement fees. Court will award Mr. Schroeder 169 days credit towards his sentence in this cause for the days that he has previously spent in jail. Court will also take into consideration under section 1245, cause numbers CR 2310, CR 2137, CR 2138, DA 2020-514, and DA 2020. If I can read my writing on that one. 10, did you help me out there, Mr. Ashmore?
74, Judge, 74.
That's what I wrote, but it didn't look like that. DA 2021-074. Mr. Schroeder, you're hereby remanded to the custody of the Van Zandt County Sheriff's Office so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. Good luck to you, sir.
It is. Judge, can I ask the state a quick question on the Zoom?
Sure.
May I have permission to do that, Judge? Or did you hear?
Sure.
Oh,
Sure.
okay. Guys, you sent over paperwork, but you also gave Austin paper. Are they identical? They look identical. I just wanted to make sure there
The
wasn't an
The
update.
paperwork is identical. If you would just make sure that the signed and fingerprinted copy gets sent back to the courthouse, the state will go make sure that we've signed that copy.
Absolutely. Yeah, just making sure. Thank you, guys. Thank you, Judge.
You're welcome. Are you ready on Mr. Manis?
I am ready, Judge. The issue is Mr. Manis's current mental state. Today is a good day-ish. I have tried to reach him through the video conferencing. Wasn't successful. I'll keep attempting, but he's also pretty fragile, and I don't want him brought in here if that's going to upset the jail, if the judge needs to see him, or if either I'll stick around and wait till the court's business is done. Alternatively, I'll try to visit him in visitation if we can get him in there and report back to your honor. I don't know exactly how you want us to handle it without putting a burden on the sheriff's department here. So I'm good with whatever you need, Judge.
I see that he's number 170 on the Terrell State Hospital list.
So we're getting closer, but Mr. Tabraham informed us it's an average of 400 days, and we're only about 70 in.
It's not necessary for me to see him so long as he is being monitored, and I know that the jail would contact this court if there were concerns for his health or his safety. If you could spend some time with him and just as his court-appointed attorney, and just lay eyes on him, and then you can report back to me if there's any other issues that we need to address. Otherwise, I'm fine with leaving him there. I don't want to disturb him any more emotionally than he already is.
Yes, Judge, I appreciate that. And again, we're here to serve, so let me do that, and I'll report back to the court.
Okay, well, let's go ahead. I'll just give you a new date, and then if you want to do that today, that's fine. If you want to do it another day, that's fine. Just so long as you're talking to him at one time or the other, just so that you can check on him for me.
Absolutely, Judge.
Let's go ahead and we'll reset him till. Are you available on February 8th? We'll just do a status on him that day.
Judge, I think that is a really exciting trial date on a roof case. You really would want to, you have trouble sleeping at night, I'd advise you to come to that hearing. So I think that's the one day in the month of February, the 8th and 9th, that I'm not available.
What
Yeah.
about the 10th?
Well, only if the defendants are done talking about metal roofing and nuts and bolts. It's gonna be a barn burner. Watch.
What about February 22nd?
That one will be perfect.
Okay.
And I'm sorry, Judge, that's a special set, so I just don't know. We should be done, but I don't know if 2 days is long enough. I think the judge will have had enough of us after 2 days. I don't know if there's two defendants, so there's gonna be a lot of questions and a lot of witnesses, but the 22nd works, Judge.
So that's 2, 2, 2, 2, 2.
Right on. I'm putting it on the calendar. You're right.
And if you do not have any other settings in my court on that day,
Mhm.
then obviously, this is pretty much going to be a status. If you want to appear via Zoom, just let us know you're going to appear via Zoom. Don't
Okay,
need to come over here unless you need to unless you want to talk to him or see him and check in on him.
Yes, Judge. Thank you so much. I think that's all my business. Thank you for
Thank you,
working
Mr.
with
Ashmore.
Austin and Joe this morning.
Yeah, absolutely.
And Merry Christmas. If I can maybe excuse, I'll see you in a week.
Yes, sir. Sounds good. We'll see you soon.
Thank you.
Deputy McLeish, I need just a few minutes, okay? I gotta take care of one issue here in the court.
Yes, sir.
Deputy McLeish. John Mosley. We want to bring him up for an extradition. We can bring up Mr. Shalet, Mr. Brown, also for their KPS profiles.
Okay, we do have Mr. Brown and Mr. Shalet in the room.
Okay, we can go ahead and do theirs first.
Okay,
And so before we do the extraditions on Mosley, has this been signed by an officer here? I'll need to swear somebody on that extradition. Or it can be sworn by another officer there.
it's usually yours truly.
Okay. So if you're doing that, if you'll sign right there.
On where it says affiant.
Yes. And do you swear that the foregoing information is true and correct to the best of your knowledge, Deputy?
Well, let me review it first, Your Honor.
Please do.
Meanwhile, could you go get Mr. Mosley, please? Mosley? Yes, sir. And no, Your Honor, there's some, I need to fix this paperwork.
Okay.
I'll certainly work on that.
All right. So is Mr. Brown in there?
Come on up, sir.
Yes, sir.
All right. Are you Troy Brown?
Yes, sure.
All right, Mr. Brown, I show that you're being held in custody on KPS profile warrants from some of your previous criminal cases.
Yes, sir.
And I'm looking over what's been reported to me. It involves 4 different cases. These are, and I don't know what the convictions are for. I can just tell you the case numbers are CR 09-280. You owe $309.01. CR 10-122. You owe $1,898.94. CR 10123, $1,273.70, and CR 1561, which is $1,864. Your total KPS profile fees are $5,345.65. Show that you also owe restitution, late fees. Those totaled $28,269.06. So let me ask you, have you not been on a payment plan to try to discharge these things and avoid being arrested and placed in jail?
No, sir, I haven't. Not that I didn't know
You didn't know what?
that I remember when I first went to prison where the numbers come about, but I didn't know nothing until I got arrested the other day.
Do you have do you have a job?
Yeah, I was supposed to start yesterday at a job.
What kind of job?
Car accident in on Willowbranch Road in Van. But I just put firewood and stuff like that. I
Firewood?
had money to put towards it if there was a way I could make a payment plan today.
How much money could you pay towards your delinquency?
Sir?
How much money could you pay towards what you owe?
Oh, no. So I do have money to pay on it if I could set up a payment plan or something. I got 2 kids that, you know what I'm saying, that's all my money goes to is my kids.
You said that you do have some money if you can set up a payment plan. How much could you pay today?
I can pay $300 a day.
You could pay $300 today. How
Yes,
much could you pay each month?
I didn't pay nothing a month. I didn't
No.
know.
No, listen, I'm talking about if I let you out of jail, how much could you pay each month?
But would 150 be good? Because I have 2 kids that, I pay $150 a month.
You can pay.
If more, I can squeeze it out more if I can.
Do you have somebody that could come and pay the $300 on your behalf?
It's on my books right now.
It's on your books.
Yes, sir. Yes, sir. I mean, I can release it to whoever I need to release it to.
Okay. So if I take a $300 payment towards this balance today and I release you, then you're going to report to the court compliance officer, you're gonna pay $150 a month.
Yes, sir.
All right, I'll do that.
Yes,
I'm
sir. Thank
gonna give you that, I'm gonna give you that opportunity. If you don't, what's gonna happen?
you. You throw me in jail until whenever you want to let me go?
Well, you end up going back to jail, and we have another hearing about why you didn't pay, and if you don't pay, then you sit in jail a lot longer.
Yes, sir.
All right?
Yes, sir.
All right, I'll send out an order later. You need to make arrangements to release that to the district clerk's office. You need to fill out whatever paperwork that the jail needs you to do to where you can pay that over to the Van Zant district clerk, and that money will then be taken by the sheriff's office. We can pick it up, and it can be paid to the district clerk, and you can get a receipt of that, and that'll go towards what you owe. Okay. So once I get through with court today, I'll have that order sent out there. And then once you're released, if you're released before 5 p.m., I want you to report over here to the Van Zant County Courthouse immediately and meet with Bonnie LaPrade on the 3rd floor and set up a payment plan for $150 a month. If you do not get out before 5, then I want you to report sometime before 5 p.m. tomorrow and take care of it.
Yes, sir.
Okay?
Thank you.
You're welcome.
Have a seat. Bless you. Thank you.
Yes, ma'am.
I have Mr. Gillette and Mr. Mosley both in the room.
All right, Mr. Gillette. All right, Mr. Gillette. All right, you are also being held on KPS profile warrants on 6 different cases. I show that you owe a grand total of $5,917.10. Have you been making payments towards that?
No, sir, I hadn't. Like the guy this morning told me, you know, he said if I bonded out on the other ticket I had today, that to go straight over there in the morning and make a payment with them. The judge I seen this morning, he said they, you know, because I have another, you know, I've already called bondsman, you know, and bond out on this other ticket. He told me to go ahead and go straight over there in the morning.
Yeah, so what are you being held on right now?
I'm not sure what it is, destruction of property, something like that.
Do you know what your bond is?
$15,000.
15,000.
And a friend of mine's they're on their way over here now.
To bond you out?
Yes, sir. And they told me if I bonded out before morning to go straight over there and make a payment plan with them.
Yeah, the only problem is you're not gonna be released once you bond because you've got these warrants holding you on these fines. So you'd be looking at, if you set these fines out, you'd be looking at another 2 months in jail.
Yeah, but I mean, he told me this morning that he was gonna, you know, he wasn't gonna hold me on them if I bonded out and go straight over there if I got out. That's just what he said this morning.
Yeah, well, the magistrate doesn't make the decision on whether or not you're held on these things. These are my warrants, and so the jail's not going to release you unless I send over an order that says release you. So let me ask you this: if your friends make bail for you, how much could you pay towards this so that I would give you an order saying that you could get out of jail?
I've got about 150 in my wallet right now.
What do you have not in your wallet?
Get paid Friday, you know, and I have a little money owed to me in Grants Lane. So, I mean, I could probably pay another 200 Friday.
So you could pay 150 today and you could pay 200 on Fridays. So you could pay $350 this week.
Yes,
How
sir.
much do you think you could pay a month?
Well, I'd probably pay at least 150, 200, because I have two kids too, young little twin girls.
Not doing them very good, are you, sitting in jail?
No, sir, I'm not.
Yeah, you gotta take care of your business. All right, so what I would be willing to do is I would accept 150 today and 200 on Friday. You have 150 on your books today in your wallet,
I guess they put it on my book, it was in my wallet,
cash?
cash.
All right, so I want you to do the same thing that I told Mr. Brown to do, is sign that over to the Van Zandt County District Clerk's office for payment towards your KPS profile. And I will send over an order that releases you. That's going to be conditioned on two things. One, that you pay $200 to the clerk's office, to the compliance officer here in the courthouse on Friday, on or before Friday, and that you also have a payment plan of $150 a month.
Okay.
All right. That means I'll let you out today, and if Friday comes and goes and you don't do what you're supposed to do, then I'm going to do what I have to do. Okay.
All right.
All right. So you do the paperwork on your end. I'll do the paperwork on my end. Okay.
All right, thank you.
All right. You are. All right, so let's touch, well, first of all, can you ensure that someone there in the administration knows what we're trying to accomplish with those two gentlemen, that they have cash on their books that they are wanting to pay over to the county in order to have them released on KPS profiles?
Yes, Your Honor.
Just make sure they know what we're trying to accomplish so it doesn't sound foreign to them.
Yes, Your Honor. And I assume there's going to be some kind of documentation sent over here from the, okay.
Yeah, so what I would be sending over is a KPS profile order that says that they've made a payment of X and that they're going to be released, so there would be an order to release them upon that payment. But I want to make sure that the money gets transferred out of their name and over to the county before they're released.
Yes, Your Honor.
Okay. All right, so now back on John Mosley.
Yes, sir. He is present, and I can now swear to the accuracy of the affidavit.
Okay, all right. If you'll raise your right hand. Ma'am, do you swear that the information contained in the affidavit concerning John Mosley, wanted individual, fugitive from justice out of Tuscaloosa, Alabama, is true and correct to the best of your knowledge?
Yes, Your Honor.
All right. All right, if you'll sign there where it says affiant, and Mr. Mosley, if you'll step on up. Good afternoon, sir.
Pardon?
I said good afternoon.
Good afternoon, sir.
Are you John Milton Mosley?
Yes, sir, I am.
Mr. Mosley, I have documents that tell me that you are a wanted individual, which is why you're being retained in the jail here in Van Zandt County, Texas, that you are wanted out of Tuscaloosa County in the state of Alabama for a felony offense of theft of property. Is your date of birth April of 1961?
Yes, sir.
Okay. So, Mr. Mosley, the purpose of today's hearing before me is for me to admonish you of the extradition process. So, since you are a wanted individual in another state, the state of Alabama can only get your body back to their state one of two ways. The first way is you waive extradition and you willingly allow the Alabama authorities to come back, come to the state of Texas and pick you up and take you back to their jurisdiction for you to face whatever charges they have for you. What I see here is theft of property, a felony. That's one option. That's called a waiver of extradition. If you do not want to waive extradition, then the formal process that the state of Alabama has to go through is they have to send up a legal request through the Alabama governor's office for you to be returned to their state. And the Alabama governor's office then contacts the Texas governor's office for them to certify information that you are the named individual in the legal proceedings there, that it's a felony. Once your identity is affixed, then you would be commanded to be sent back to Alabama. So the extradition process for you, the hearing does not include a trial on the merits of the claim or anything like this. It's a legal procedure wherein one individual is moved from one jurisdiction to another across state lines. If you sought to have the state of Texas or state of Alabama extradite you, you are entitled to the appointment of counsel here in the state of Texas to test the legality of that extradition. That means they would have to make sure that the state of Alabama follows all of the legal procedures correctly before you could be transported back to their state. So that's kind of the rough overview of extradition proceedings.
May I say something?
Yes, sir, please.
What is supposedly I'm charged with? I mean, what have I done?
I have the charges that I show here it says theft of property, second degree felony. I have your address listed there on Fox Hollow Lane in Tuscaloosa. Looks like control over livestock to Charolais calves.
How many Charolais calves?
It could be 2, could be 7.
I don't even know what we're talking about. Honestly, I don't.
I understand.
I mean, I've been right where I'm at for 20 years. Me and my wife are both property owners. Everything we have is paid for. I'm not a thief.
Ms. Deputy McLeish, do you have this document there with you? It's the it says Alabama Judicial Information System complaint. It was my very last page. Can you let Mr.
I don't have my glasses on, so I can't see.
Okay, well,
Please, thank you.
I will tell you that it says that this happened on or about March of 2000. So,
Okay.
so what they're alleging is 20. And listen, I can't really discuss facts with you because I don't know what the facts. I'm just reading these documents and telling you that this may be an old complaint. To me, it looks like it's an old complaint from 21 years ago.
That's what I said. I left Tuscaloosa June the 1st of 2001. If there was a warrant for my arrest, they could have got me then.
I understand.
And all this time, I mean, I've been stopped several times. I've had several traffic citations. Why couldn't they have arrested me over that time?
It's a good question. Yeah, it's a very good question. I don't know. I wish I had more answers for you. The only answers I do have for you are there's 2 ways to resolve these charges. One, you allow them to come pick you up, take you back, and you address this with them. Or 2, you say, no, Alabama, you come and formally request me from the state of Texas.
No, sir, I'm not going to be extradited back to the state of Alabama. I hadn't done anything. And probably what this is about is, and I'll be honest with you, I used to do some cowboying down there.
Well, and let me caution you just for a second. One, I don't want this to come across as rude, but I'm really not concerned or interested in what you did or didn't do. It's my job here to admonish you about, the legal rights regarding extradition. So if you do not want to waive extradition and you want the state of Alabama to request issuance and service of a governor's warrant of extradition, then I will send that paperwork back to Tuscaloosa And then basically you will have moved the ball back to their court for them to decide what it is they want to do. And you're perfectly within your right to say, no, judge, I don't want to do that. And what I would do is in 30 days, if you're still sitting in my jail and we do not have any information about a governor's warrant, then what I would do is bring you back for a hearing and very likely set you a bond that you could bond out on and then wait to see what Alabama's going to do.
So in other words, I can't bond out today.
Can't bond out today. Not from my county. Not from my county.
Well, you know,
If you go back to Alabama, I'm assuming that you can bond out.
if I go back to Alabama, I can bond out.
I mean, I don't have any reason to believe that this is a no bond case, meaning a case where you're not allowed to post some kind of bail surety. But I know that you're not going to be able to bond out here because the warrant's been served on you, and the extradition process has to be given its opportunity to work.
This is 21 years ago. If I did something wrong, why did they wait 21 years to?
No, I understand, and you may have a very strong equitable argument there. Unfortunately, I'm not the judge that adjudicates that. I'm not the one that gets to decide whether this has gone on too long or that they didn't exercise diligence in trying to find you and arrest you.
They knew where I was because 12 years ago, my wife, they contacted us and said, when I left Alabama, I had closed down an account and I had 2 checks. It was bad. I said, okay, send us the information, we'll pay it. They did, and my wife paid it. That was 12 years ago. They knew where I was the whole time. Why did they wait 21 years to try to do something like this 21 years from now?
I understand. I can't allow you to bail here right now because the extradition process needs to be given opportunity to work. But so the way I see it is in 30 days, if you're still here, then I will allow you to post bail.
Yes. Well, the thing about it is I have a bunch of cattle. Me and my wife, there's nobody but me and her. I have a bunch of cows. Somebody's got to feed them cows. I've got tractors and equipment stuff that I have to take care of. Like I said, I'm not a criminal. I don't steal. I don't do anything wrong. I go to get Copenhagen Friday morning. I tell my wife I'll be back in a little bit. She's fixing breakfast. I pull in a Brooks's parking lot and they got me for speeding 5 miles over or something. Next thing I know, I'm in handcuffs headed up here.
Where do you live at now?
I live at 6741 FM 16. When you go up underneath the interstate there on 16.
Hang on. Just give me the address again.
6741 FM 16.
What town is that addressed to?
Man.
What's that? Zip code 75790?
75790.
57. All right, I'll tell you what I'm going to do.
I'm not going anywhere. I'm not going.
I understand. I want you to have a seat and let me check on some other things real quick, and we'll finish this up in just a few minutes. Okay.
All right, so I appreciate it.
You're welcome. Have a seat, and I'll be right back with you.
Sir, why don't you step on that?
All right, Mr. Mosley. Done some thinking, done some reading. So what I'm gonna do is I am going to allow you to post bail. I'm gonna allow you to post bail. And what I'm gonna do is I'm gonna order you to come back to my court on January 6th, 2022.
Come back to.
At 9 a.m. Here in the courthouse,
At the
here.
courthouse.
Here in Canton at the courthouse in my court on the 3rd floor, 9 a.m. And I'm going to set your bail at I'm going to set your bail at $1,500.
Yes, sir.
So if you post a cash bond of $1,500, once you resolve your case, then the money can be returned to you, or you can post that with a surety. You can hire a bondsman to do that.
What time is it right now? Excuse me.
What time is it?
If I can get a hold of my wife right now, she can get the money from the bank, the cash money, and get me out of here today.
Yeah, sure. I'll let you handle all that. But here's what we're going to do: is I'm going to let Alabama know that you are requesting that they extradite you. I'm going to reset you until January 6th. When you come back on January 6th, if the governor's warrant from Alabama has gone through the procedures and is here, then you'll be taken into custody on the 6th, put back in jail, and then sent back to the state of Alabama. Between now and then, it would really serve you well to get on the phone and call Tuscaloosa County and talk to them about this complaint. Perhaps you can get this resolved without them wanting to extradite you.
Yes, sir. I appreciate you very much. You just don't know how much.
All right. Well, just I'm gonna trust you on this, and you just don't make me regret it. Don't make me
I'll
regret
be
it.
there January the 6th, sir.
All right. And so whenever I get through, I've got a few more cases. I will get an order sent out there, setting bond at $1,500, and then you and your wife or whoever else, y'all can figure out how y'all want to post that, and then get out and then handle your business, and then then I'll see you on January 6th.
Yes, sir. Thank you very much. I appreciate you.
You're welcome.
Sign it right here.
Yes, sir. Then I'll give you a copy of that. Notice reminds you.
Go back to my cell.
Yes.
We'll do order setting bill.
Then
I can do it.
go back to my cell, call a while.
Yes, sir. Like I said, my partner, Mr. Ragsdale, can you take him back with you?
I think we'll go get the guy.
Okay, thank you.
All right, I'll give Mr. Sanders some time to talk to his clients, and then I'll be right back. I'm
Thank
gonna go work on that order for Mr. Mosley.
Thank you,
Judge,
sir.
Judge, is Miss Patty in? I see she's on Zoom. Do you have any idea if she's here?
Maybe.
Okay,
Who wants to know?
I do.
For what reason?
We have a defendant whose mother is contacting us. He has Miss Payne and would like to request a court-appointed attorney. If we can get Mr. Grace, the court-appointed attorney stuff, I told her that I would get with Miss Patty, make sure that was taken care of.
Okay, Mr. Grace is on yesterday.
As long as whatever process is going, that's fine by me. I just told her that I would speak to Miss Patty to start the process. I told her I can't talk to her. I just try to get him through the process and get it started. Beyond that, DA's office has no business commenting further. I just want to make sure whatever process is being begun is begun. That's all I care about.
Okay.
Step to the podium, yeah, come on up, sir.
All right, Mr. Sanders, are you ready with Mr. Musgrave?
Yes, Your Honor.
All right, let me kind of go over these terms real quick to make sure that what I have is what the proposed plea is. Mr. Musgrave is going to plead guilty to third-degree felony offense.
Actually, Judge, let me stop there. Judge, I was gonna ask if we could reset his cases because he is back in jail on 3 new felony charges. And so rather than proceeding on what's been indicted, without knowing too much about the new cases, I felt like it might be best to try to get everything wrapped up together at once. I think he got arrested November 15th. So there's 3 new, from what I understand, 3 new felony cases.
State.
Your Honor, I'm not opposed to resetting the plea in light of this. However, the state would make an oral motion at this time, and the state has provided the court with orders in concurrence with this, that the 2 pending charges that were supposed to be pled to today, that the bonds be held insufficient on those, and the bonds be raised in accordance. I believe I requested a $100,000 bond on one and a $250,000 bond on the other. Given the fact that Mr. Musgraves did pick up 3 new felonies, 2 of which involve a firearm during his pendency of those matters.
Mr. Sanders, do you have a position on the state's request?
Judge, obviously, speaking on behalf of Mr. Musgrave, he would obviously not want that to happen. At the same time, I expected that was a possibility as far as the bond situation on the 2 other indicted cases.
I want to give Ms. Grisham just a second here. She's trying to quit early on me. All right, so in cause number CR 287 and CR 21267, the court is going to grant the state's motion to increase bond. In cause number 87, CR 287, court's going to find Mr. Musgrave's bond insufficient on the basis of new charges, and it's going to increase the bail in that case to $100,000. And in cause number CR 21267, court's going to set new bail at $250,000, finding the previous bail to be insufficient. And Mr. Sanders, if Mr. Musgraves wants a hearing on those, then you can file a motion with the court and we'll set it for hearing.
Yes, Your Honor.
And we'll reset Mr. Musgrave's cases. State, do you have, probably asking a lot, but do you have any idea of when, even if these cases may be going to the grand jury?
Your Honor, we do not have any information from the arresting agency. I actually don't even know who the arresting agency is. Given that these are about a week old, I don't expect it to be, frankly, anytime soon.
Are you available on February 8th, Mr. Sanders?
Yes, Your Honor, that's fine.
All right, court will set Mr. Musgrave then for status on plea on February 8th. And if you need a hearing before then, Mr. Sanders, let me know. We'll get you scheduled.
Okay. Okay, we will, Judge. Thank you.
All right, I believe that concludes our criminal docket for the afternoon. Thank you, Mr. Sanders. You're excused. Good to see you. I appreciate you getting over here.
No problem, thanks.
Thank you, Deputy McLeish. Appreciate your help.
Thank you, Your Honor. Have a good day. We'll see you tomorrow.
You soon.
Thank you, Judge. May state be excused.
Yes, ma'am. Thank you. You can leave too, Tyler.
Thank you, Judge. I just didn't